Hello. So, the FMC has released their highly anticipated advance notice of proposed rulemaking. And now they want to know if they should include NVOCCs and ports. Let's dive into it. Hi. Welcome to By Land and By Sea, attorneys breaking down the week in supply chain. I'm Lauren Beagen, founder of Squall Strategies, a maritime legal consulting company, and I'm your favorite maritime industry LinkedIn Live host. My surface transport co-host, Matt Leffler, unfortunately won't be able to join us anymore. As you may know, he recently took a great new job, so that has him very busy during this time. But don't fear, we'll fill this time with fun, educational pieces, and I'll be bringing in guest speakers every now and then to learn a little bit more about their roles in the industry and how it relates to the supply chain. So let's dive into it. So what is an ANPRM? Last week we discussed demurrage, and it's a good thing. It's almost like I knew this ANPRM was coming out. Well, I did. I didn't know the exact timing. I didn't know when exactly it would be released. But a few weeks ago at the FMC's commission meeting, they said that they expected their ANPRM to be released soon. So what is it? It's the beginning of a rulemaking, of course. It stands for Advance Notice of Proposed Rulemaking. You know, so much about the federal government is alphabet soup, and this is another piece of that. The ANPRM, or the Advance Notice of Proposed Rulemaking, is the initial stage where the FMC wants feedback from the industry to help them shape their final rule. So who's the FMC? We've talked about this a few times. I'll always keep bringing it up. I want this LinkedIn Live to be very approachable. I want people to learn things here, and I want to make sure we're all on the same page. So I've described them before, I'll describe them again. The Federal Maritime Commission is the independent regulatory agency tasked with regulating the U.S. international ocean transportation system for the benefit of U.S. exporters, importers, and the U.S. consumer. So essentially, they regulate the ocean-borne transit, the ocean-borne cargo, the blue water side of it, so to speak. So what is the FMC asking? The FMC is requesting feedback on the following. Essentially, they're looking at scope, minimum billing information, and billing practices. So scope. They want to know, should the final rule include NVOCCs and MTOs, in other words, ports, in addition to the VOCCs that are already being included? And you may remember, we talked about this prior, VOCCs, there's an audit team that the FMC has stood up that's reviewing some of these practices. There have been a few different iterations of guidance coming out from the FMC, but this rulemaking is really the first time that they are reaching out to the public and want feedback. Well, not the first time, but this is the mechanism for this feedback. They want this feedback to come to them so that they know what's going on in the industry. This is your moment. This is your moment to chat with the FMC, this federal agency, and tell them what's going on. So the commission notes that although MTOs often don't actually have direct contractual relationship with the shippers, as we know, rather, it's usually the VOCCs that are the direct relationship there. There are some situations where MTOs do impose the fees directly on shippers. In the rulemaking, the FMC actually noted MTOs are entitled to separately assess demurrage as an implied contract in a court of law, provided there is it's published as part of the MTO schedule. So MTO schedules, we've talked about this before. MTO schedule is essentially an MTO tariff. It's your list of prices that you publish on a public website, so usually on your own website. And the FMC will also reference over to your public publishing of that schedule. So that they're noting that sometimes the MTOs or the ports have their own tariffs, and through that they might create this implied contract. They might create a contractual relationship with that shipper. So that's essentially they're saying when that happens, that's where these regulations might apply to MTOs or ports. The commission is also seeking comments on any other laws or regulations or arrangements that might affect the regulation of detention and demurrage billing. So they've referenced in their rulemaking that there's a couple other laws that also circle around charges and invoicing of the cargo boxes. They want to know what they don't know. And that's why they're asking the industry right now through this rulemaking, What don't they know? What should they know? What else should they take into consideration? What are you also up against that you want to make sure you don't get overly regulated? This is your chance to make sure that you don't get, or that you can try to be a little less overly regulated. So the FMC is also looking at minimum billing information. So what exactly is that? They want to know, should the FMC require minimum billing information for detention and demurrage invoices or D&D invoices? The intention here is to provide visibility and clarity in the billing method. Examples of this might include regulating that the invoice actually indicates the period you're being billed for. Sometimes the invoices might just be, for I don't know, a couple $1,000, but they don't actually say, when was that? When, like, you're telling me that I owe you demurrage on this cargo sitting, but you're not telling me how long or what. It's a little inconsistent, maybe a lot inconsistent in the industry, and they want to hear that. They want to hear from the industry what's going on, what's really difficult about billing that you'd like to see cleaned up from a regulatory standpoint. Maybe they require how the charges are actually calculated. The FMC in their rulemaking announcement also provides the specific example, talking about import and export procedures. So perhaps requiring identifying clear and concise container availability dates in addition to vessel arrival dates for import shipments. So listen, I'm going to say that again. Potentially requiring identifying clear and concise container availability dates. Wouldn't that be amazing? Container availability dates, in addition to vessel arrival dates. And then for the export shipments, the FMC, and like I said, the FMC, these were their examples in their document. But for the export shipments, potentially providing the earliest return dates, as well as availability of return locations and appointments where it's applicable. Wouldn't that be nice? Wouldn't that be nice to have some sort of regulation around that? And if there are pitfalls, if there are ways that you want that applied but not overly burdensome, put that in some comments. Submit that to the FMC. Like I said, this is where they want to hear from the industry. They regulate this industry, but hearing from the industry directly is what they're seeking here. An ANPRM, let me go back, an ANPRM, an Advance Notice of Proposed Rulemaking, they didn't have to go through that phase. They could have skipped it. They could have just gone forward with a proposed rulemaking. And at that point, they would propose the rule and how they want it to be shaped. And then they would solicit comments. But at the Advance Notice of Proposed Rulemaking, they send out some questions to the industry, and they're hoping to get feedback back. So they haven't drafted this rule yet. They really want to hear the perspective of the industry, and they want comments. They want feedback. They want to hear what are some things to avoid as they draft it. Obviously, they have some ideas of where they want to move, and you've seen that through a couple of their fact-finding missions and a few different iterations of them releasing information. But at this point, they want to work with the industry, and so they've done this extra step, this Advance Notice of Proposed Rulemaking, to really dive in and find out how they can make it the best for the industry. So the third thing that they're looking at is billing practices. Should the FMC require billing invoice timelines? Among other things, the FMC is specifically asking for comments on a requirement that demurrage or detention bills be issued within 60 days of the occurrence of the charge. Makes sense, right? That's 2 months. 2 months from when the demurrage or the detention actually occurred. So the FMC, like I said before, has given some examples through their rulemaking announcement. They give another example here. So if a shipper receives a demurrage or detention bill months after the occurrence of the charge, they may no longer possess the necessary materials to confirm the charges are correct or to access the information necessary to dispute the charges. The FMC actually says here too, the longer it takes to receive a detention and demurrage bill, the more difficult it may be for a shipper to validate the accuracy of the charges. Makes sense. This makes sense that this would be a cleaned up area of the industry. If you're allowed to invoice months, years after detention and demurrage actually occurs, I mean, that's troublesome, right? I mean, you won't have the information. You're not going to be in the moment. You probably have a lot of different cargo and, weekly that you're trying to remember this specific detention and demurrage charge. If they're required to issue the bill within 60 days Imagine how much more they're going to be cleaning things up here. They also want some feedback on whether they should require clear dispute resolution instructions. So what that means, dispute resolution. So what to do if something goes wrong or you dispute the amount that's being charged to you. If there's no way of recourse, you get this bill and you might send back an email and say, I don't agree with this. You maybe never get a response back. If the FMC requires that clear dispute resolution instructions or clear instructions on how to challenge or dispute the charges are clearly outlined by the issuer of the invoice, that would be wonderful. Then you know who to email or who to contact to start at step one. Respond back and say, I'd like more information, or I dispute this because of this, this, and this. If there's a dispute resolution mechanism in place already, that's going to help the industry overall. And it's also going to encourage a little bit more visibility and a little bit more, perhaps, movement away from wrongdoing. So in this rulemaking, the FMC is able to explain their intentions with the rulemaking and clarify some points. So if you pull up the actual rulemaking document, you'll see that they actually are making it crystal clear the purpose of detention and demurrage. The FMC says, and I quote, "Demurrage and detention charges and policies should serve the primary purpose of incentivizing the movement of cargo and promoting freight fluidity." The FMC is also defining detention and demurrage. They say, for the purposes of this ANPRM, this Advance Notice of Proposed Rulemaking, the Commission defines the terms detention and demurrage broadly to include any charges assessed by common carriers and marine terminal operators related to the use of marine terminal space or shipping containers. Very broad. Under this, the FMC continues, under this definition, for instance, charges assessed by common carriers for the use of containers outside of a marine terminal would fall within the scope of this ANPRM, regardless of whether the charges are called detention or per diem. So they're trying to make a distinction here. Whether you call it detention, whether you call it per diem, whether you call it rental space, whatever you call it, they want to say they're including all of that. It doesn't matter what it's actually called. It matters what's happening. And so charges assessed by common carriers for the use of containers outside of a marine terminal is part of this detention. Similarly, the FMC continues here, similarly, charges assessed because a container is taking up terminal space would fall within the scope of this ANPRM, even if the charges are called something other than demurrage. So we've talked about this. Demurrage is essentially the container taking up space, and this is the rent being charged for that taking up of space. The FMC is saying, I don't care what you call it. If it's essentially this definition of demurrage, that's what we're looking to talk about here. Essentially, if it walks and talks like a duck, use of the container yard, or takes up space on the yard, it's a duck. It's detention and demurrage. It's not a flower or some other random fee name that you've created or somebody has created to try to slide around the rules here. With the intention of trying to avoid the detention and demurrage label. They're saying, look, we all know what we're talking about here. We want to talk about that for this ANPRM. So that's what they're looking for. Those are the different subject matters that they're looking for. Do you have thoughts on that? I'm sure you do. They want comments, and there's no harm in submitting the comments. So I'd like to put out there right away, comments are for the most part filed and they'll be public. So there is a docket, docket number 22-04, and I'll make a link to the docket so that you can see the other comments being filed. But if you file your comments without requesting confidentiality on your comments, then you will be part of that docket number 22-04. And through that, other people will be able to see your comments as well. So how do you submit these comments? You email the secretary at fmc.gov. So her email or his email is secretary, secretary, secretary at fmc, Federal Maritime Commission.gov. Make sure to include your docket number 22-04, and subject line needs to make sure that it has docket number 2204, and some sort of indicating, D&D ANPRM comments or rulemaking comments. Your comments should be in Word format attached to your email. And the comment period, this is the most important. The comment period is only open for 30 days. So it's 30 days from when it was filed, when it was published in the Federal Register. So that puts us at approximately March 4th. So you already are down a week, and you will have 3 more weeks, essentially 30 days total, to file. So March 4th, put that in your calendar and put a reminder a week before that. So that's how you file the comments. But what should you say in the comments? These are just general suggestions. And like I said, nothing here, it should be construed as legal advice. There's no attorney-client privilege here. But in general, if you want to file some comments, what should you put in it? Comments filed can run the whole gamut. They can be totally off base. What I guess I'm trying to say here is don't be afraid to submit comments. If you really have something that you'd like to send to the FMC and you're comfortable with it being on their list, they're likely to get a lot of comments on this. It's going to be of the bunch. If it's a legitimate comment, they have to respond to it when they start working on their actual proposed rulemaking. So how should you present your comments? Right off the bat, I suggest you introduce yourself. Who are you? What's your role in the industry? Why should the FMC actually take your comments into account? They want to know, okay, so why should we listen to this person? This person is a shipper, or this person owns a yard, or this person is a warehouser, or whatever your role is. Talk to them through your comments. Make sure that they know who you are, though, so that way they can kind of understand the global picture, the larger image of where you fit in. But on top of that, state your position in the industry. If you didn't do it in your introduction right off the bat, identify your role in the industry and explain what the nature is of your business and its relationship to the rest of the supply chain. Don't assume that the FMC actually understands the nature of your business. Give a little overview explanation to make sure it's perfectly clear. The whole point of trying to do this by land and by sea was that we really wanted to break down some of the siloing that happens in the supply chain of the land and the sea side. And so this is a moment to help break down that silo. Don't assume that the FMC actually does understand the nature of your business. Explain it. Explain it simply, because the simpler that you can present your comments and present your role, the more effective it's going to be. Start your comments at that point. You've introduced yourself, you've talked about who you are, you've talked about your role in the industry. Start your comments. So what kind of comments can you include? You can include comments that are stories or examples or general perceptions or perspectives. You could identify problems that you see in the industry. Those 3 areas, the scope and the billing practices and the billing practices and the minimum billing information. Those three areas are the areas that they want to prompt you on. But if you have other feedback, feel free to jump into it. Send along whatever you think is relevant. Make sure to keep the FMC's questions close by and try to keep your comments related. But at this stage, the FMC just really wants to hear your feedback. So, like I said, stories, examples, general perceptions, perspectives. So after that, what do? I would suggest make a suggestion if you have one. You don't have to have a suggestion for how to clear it up. Like I said, they want to know what's happening in the industry out there. And perhaps the more times they hear a certain story, the more it'll start to take shape on, well, we need to address this. We need to figure out how to fix this. So if you have a suggestion, feel free to put it in there. Now that you've identified the problems or provided a story, do you have any suggestions? So how should the industry be cleaned up? What oversight might a federal agency add that will help solve the problem? Remember, this is a federal agency and they're trying to shape how they regulate. And so keep that in mind. They're limited in what they're able to do. They're very effective, but they are limited in scope. So what oversight or regulations or requirements might you want to see out of a federal agency in this area? You don't have to have a suggestion though, but that'll definitely help the FMC's rulemaking. So are there ways that you suggest the FMC shape the rule or areas that you think are open for bad actors? Include all of that. So a few things to know. I can't say it enough. I'm going to say it again. This is not legal advice. This should not be construed to be legal advice creating an attorney-client relationship. If you do have specific questions, contact an attorney. You can contact me directly through Squall Strategies, but contact an attorney if you have specific attorney questions. Like I said at the beginning, this is just a suggested format for filing comments. There's no best method. The key is clarity. And remember, comments are public. These comments are going to be public unless confidentiality is requested. And there is a method for confidentiality, but they have to meet a few confidentiality threshold requirements to be filed confidentiality. So in general, I would say approach it as though your comments are going to be public. And if you're very, very interested in the confidentiality filing, look into the confidentiality requirements as actually they're stated right in the rulemaking. So, but like it's probably safest to just assume your comments are going to be in the public realm. So keep that in mind as you share your thoughts and experiences. You will be able to see other comments being filed. And like I said, I'll link that, the docket area, so that you can watch over the next few weeks as the FMC starts to get these comments in and starts to post them onto the docket, what other people are saying. You might even start responding to some of those comments that are filed, or it might spur some thoughts in your own mind. You know what? I have some thoughts too. I want to file some comments. The length of the comments, there's no minimum or maximum length. If the comments are relevant, the FMC for the most part really has to respond to them. They might group together thoughts, but if there's relevancy to the ideas being presented, the FMC has to respond to them as they create their proposed rulemaking. So again, how do you submit the comments? You email them to secretary@fmc.gov. Make sure to include docket number 22-04 and some sort of identifying title. I suggest D&D rulemaking or detention and demurrage rulemaking or comments on the rulemaking, something that, you know what I mean, something that lets them know what you're emailing them about. And make sure to attach your comments via a Word document. You could also do a search-rich PDF. Either way is fine, but make sure that it's an attachment to your email, and don't forget to attach the attachments. So again, guidance here is general and for educational purposes, not construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. So this is Lauren Beagen, and you've just listened to By Land and by Sea. I don't see any comments on our live feed here, but I'd be happy to answer any questions that you may have. Contact me through Squall Strategies, and we'll see you next time. Thank you.